Hey, it's Bernard Nomberg with the Nomberg Law Firm, and I wanted to take a minute to address an area of the law from civil procedure, things that we deal with when we have a case in court and it's prior to the time of the trial. It's typically at the end of the evidence period, the end of the discovery period, but prior to trial. Either party to a case can file a motion for summary judgment. Motion for summary judgment is basically the litmus test for a judge to determine whether or not a case can move on to the next phase of the litigation, the trial phase. And it's a test. It's a test for the judge to determine whether or not the evidence that's in the case meets the standards that the law provides, the guidelines that are necessary in order to have either a jury or a judge try the case and hear the evidence. And I'm going to read to you basically from the rules of civil procedure some of the standard here. Summary judgment is appropriate where there's no genuine issue of material fact and the moving party, the party that's filed, is entitled to judgment as a matter of law. Once the movement makes a prima facie showing that no genuine issue of material fact exists, the burden then shifts to the non-moving party to show that there's substantial evidence regarding the existence of a genuine issue of material fact to be heard. Now what this means is, since either party can file, let me just give you two examples. Typically, the defendant in the case, the party who's being sued, they'll file a motion for summary judgment telling the court or asking the court, we don't believe we've heard all the evidence, we've gone through all the discovery, we do not believe that the plaintiff, the moving party, typically the injured party, has enough evidence to meet the law and that the law does not allow for them to go forward to a jury, so you should grant a summary judgment in favor of us, the defendant, and the case should be concluded. On the other hand, the plaintiff can also be proactive and go on the offense, so to speak, and file for summary judgment, saying, Judge, in fact, we have enough evidence here that there are material issues that should be heard at a trial. While either party can use it, can file it, typically it's going to be the defense, the defending party. If you have questions or concerns about how this operates and how procedurally this works, give us a call. This is the kind of work that we do. It doesn't happen very often in workers' compensation cases, but it does happen occasionally. It's mainly in tort cases where there's slip and falls. It could be in a contract case. It could be in a medical malpractice case. It's a fairly commonly used procedure in civil cases. Please give us a call at 205-930-6900, nomberglaw.com. We can also be found on Facebook, Twitter, and YouTube.